Welcome to Akin Gump's webinar on business interruption insurance and pandemic losses. My name is Sean Hansen. I'm a partner in Akin Gump's insurance litigation group. I'll be your moderator for the presentation today. With me is a smart and experienced team of Akin Gump insurance lawyers. They're going to cover first the rules of the road and significant issues under current coverages. That's going to be handled initially by Clayton Matheson and Dennis Wincheffel. After that, Aaron will discuss the several state legislative initiatives that propose to alter some of those rules for some insureds. And then she will briefly discuss legal issues relating to those legislation if it's enacted. The session will last about 50 minutes, and then we will have a live question and answer session at the end. If you have questions, please submit them during and after the presentation using the moderator chat button on the right-hand column of your screen, and we will do our level best to answer all your questions after the presentation. Alternatively, please feel free to reach out to any of us at your convenience. Our contact information is on this first slide that you'll see, and we will be happy to talk with you about specific questions and answers as you develop them. You should also know that CLE credit will be available to any of those who would like it. You will need to use this code. The CLE form will accompany this set of slides and the verbal recording of the presentation that you should get within a day or two of the presentation. And then you will need to use this code, and I'm going to say it twice, AG0417. Once again, that's AG0417, and use it. That will complete the form that will accompany the slide set and the presentation today. Obviously, if you need that, you can always email any of us and get it directly from us as well. So without further ado, let me hand the presentation off to Clayton, and we'll talk again in 50 minutes or so. Clayton?
Thanks, Sean. As Sean mentioned, Dennis and I will be leading the first half of our discussion today. And we are going to talk about the key business interruption coverages and coverage-related issues implicated by the coronavirus pandemic. Of course, the pandemic also implicates numerous liability insurance coverages and issues related to other types of policies such as D&O, CGL, employment practices, and other similar coverages. But today our focus is on first-party property insurance and business interruption coverage specifically. For obvious reasons, this has become a prominent part of our practice over the last couple months. Starting with a sort of 10,000-foot view, as you can see on the slide, the typical commercial property policy provides two basic coverages. First is coverage for damage to physical and structures and personal property, which for a business would include inventory. And this, of course, is the type of coverage that probably comes to mind when anyone thinks about property insurance. The second type of standard coverage, however, that also appears in most commercial property policies is business interruption coverage, also called business income coverage in some policies. And it generally covers income losses suffered when the insured's business operations are impaired as a result of physical loss or damage to the insured's premises. These coverage provisions also often encompass, quote, extra expenses, end quote, which are costs incurred to repair and replace the damaged property and to continue operations as normally as possible in the meantime. So extra expenses are basically simply other consequential losses flowing from property damage aside from the actual losses of income. For example, the cost of setting employees up to work at home, which may necessitate the purchase of IT services and supplies. Needless to say, business interruption insurance is a hot topic right now. We all know that the current pandemic is having devastating effects on our economy. On the screen are a few numbers we found that we think really drive this point home. As you can see, initial weekly jobless claims went from 280,000 on March 14th to nearly 7 million just 2 weeks later on March 28th. And basically in 1 month, the United States lost every new job that it had created since the Great Recession ended. Some experts believe that unemployment could reach as high as 15% in this country, and that GDP will fall 9% in the first quarter and up to 34% in the second quarter. Studies also have shown that 25% of small businesses in this country already have shut down, and that over 100 major retailers, including Apple, Macy's, Nike, and IKEA, have closed all their brick-and-mortar stores. Finally, the federal government has indicated that the pandemic could last 18 months or longer and likely will come in waves, which means that things could be bad for quite a long time. So many of those businesses shutting down and closing locations across the country undoubtedly will look to their property insurance policies to see if they have applicable business interruption protection. This is a bit hard to read, we apologize for that, but on the screen is an example of a standard business interruption coverage clause. It provides that we will pay for the actual business income loss you incur due to the actual impairment of your operations and extra expense you incur due to the actual or potential impairment of your operations. So this is an example of a clause that covers both the lost income and the lost additional consequential damages in the form of extra expenses. Now, we will get into some of the nuances of the coverage clause later, such as the threshold requirement that the impairment of the insured's operations must be caused by or result from direct physical loss or damage. For now, we just wanted to note and observe for you the basic coverage provision and language. One of our goals today is to make sure you all recognize that the straightforward standard business interruption coverage that we just looked at is not the only coverage implicated by coronavirus-related losses. These days, most policies provide additional types of coverages, which are often labeled or called coverage, quote, extensions. And we want to highlight a few that we think are particularly relevant. The first is the protection and preservation of property extension. This provides coverage for the reasonable and necessary costs incurred to temporarily protect or preserve insured property, as well as associated business income losses that flow from those protection or preservation efforts. However, any such costs and losses must be due to actual or to prevent immediately impending insured physical loss or damage to such insured property. So this potentially applies, for instance, where a business temporarily ceases operations to avoid the spread of the coronavirus. As just one example, if I owned a store located across the street from the pork factory in South Dakota, where over 600 employees tested positive for coronavirus just last week, this coverage potentially could be in play if I decided that I needed to close my store, prevent the spread of the coronavirus, and to keep my own employees from getting sick. The next extension we want you to know about is called civil authority coverage. Of course, many of you probably have heard or read about this coverage in recent weeks. We have a sample on the screen of a typical civil authority coverage provision, and it provides quite simply that this policy covers the business interruption coverage loss incurred by the insured during the period of liability if an order of civil or military authority prohibits access to a location, provided such order is the direct result of physical damage of the type insured at a location or within 5 statute miles of it. This coverage obviously is highly relevant these days, considering that over 300 million Americans, or roughly 95% of our population, is currently under some sort of stay-at-home order. With that, I'll turn it over to Dennis.
Thanks, Clayton. I'm going to talk about a few additional coverage extensions that may also be implicated. The first one that I'm going to talk about is the communicable disease extension. As set forth on this slide, this coverage provides potential business interruption income when a communicable disease is actually present on the insured's property, and as a result, there are access limitations or restrictions. Communicable disease is typically defined fairly broadly under policies, and coronavirus, which can be transmitted from human to human by direct or indirect contact, will typically be covered under the definition of communicable disease. Now, this coverage can be applicable even if the insured's management, rather than the government, is the one that orders access limitations or restrictions. In other words, you ordinarily don't have to wait for an order from the government to shut down or trigger coverage. If you have a communicable disease on the premises and you shut down or limit access to the premises, then coverage may be implicated. On this slide, this is a sample communicable disease coverage. In this particular iteration of the coverage is available if a location in which the insured has some sort of interest, whether they own the location, they lease it or rent it, and access to the location is limited, restricted, or prohibited by either an order of a governmental agency or decision by the insured as a result of the presence of the communicable disease. We'd like to point out that coverage in this extension and other coverages is typically limited by a specific period of time, which we'll be talking about later, often referred to as a period of liability or a restoration period. And this coverage, like many other coverages, is also subject to a qualifying period, which is akin to a deductible. But we'll cover those issues later on in the presentation. The next potential applicable coverage extension is dependent business off-premises services. This coverage provides potential business interruption income when the insured's operations are impaired by a dependent business or an off-premises service provider. Dependent businesses usually include groups such as customers, vendors, and suppliers. In contrast, off-premises services providers usually include utilities such as water, electric, sewage, as well as phone and internet providers. Now, Clayton talked about the requirement of direct physical loss. Dependent business coverage, like many other coverages that we have been discussing, generally require physical loss or damage at the dependent business premises. This slide is an example of a dependent business coverage. In this particular iteration, the dependent business premises include premises operated by others on whom you depend to, and then it lists 4 different kind of buckets. The first bucket is those businesses that deliver materials or services to the insured, often referred to as contributing premises. A second bucket is those groups that accept your products or services, the recipient premises. The third kind of potential bucket on this particular coverage is the manufacturing products or delivery to your customers under contracted sale. And then the fourth bucket of dependent business premises is those businesses that attract customers to your business. Now, this particular coverage is available for impairment of your operations, assuming that the impairment is caused by or results from direct physical loss or damages to the property at dependent business premises. In addition, like other coverages, this coverage is limited to a period of restoration. That period can vary greatly from policy to policy. We'll talk in greater detail about that requirement later on in the presentation. Another coverage very similar to dependent business coverage is supply chain coverage. This coverage potentially covers business losses incurred due to interruptions anywhere in the supply chain. This coverage also typically requires physical loss or damages at the premises of a party in the supply chain that impairs your business. This slide shows a sample supply chain coverage. This particular iteration potentially covers losses incurred by the insured during the period of liability, directly resulting from physical loss or damage at the premises of various parties in the supply chain. And this particular iteration, in addition to requiring some sort of physical loss or damage, is also subject to a period of liability. Another additional potential implicated coverage extension is contractual penalties. This coverage potentially covers contractual penalties incurred or that are due due to the insured's inability to perform under an existing contract. Examples include late or non-completed orders, as well as the failure to provide contractual services to other parties. This coverage also typically requires that the breach result from physical loss or damage to the insured's property. This slide shows a sample contractual penalties coverage. This particular version provides potential coverage for contractual penalties that an insured is obligated to pay under a contract for material breach. And like many of the coverages that we've been discussing previously, this coverage typically also requires that there be direct physical loss or damage. Now that we've addressed some of the potential applicable coverages, we're now going to turn to various key coverage issues. And with that, I'll turn it back over to Clayton.
Thanks, Dennis. So the first key coverage issue we want to discuss today is the direct physical loss or damage requirement that you have heard mentioned several times already. This is a threshold requirement that embodies the fundamental notion that property insurance is primarily designed to protect against things like fires and floods. But what about something like the coronavirus? Well, in the context of a virus or a pathogen, this requirement raises two questions. First, has the virus in fact spread to the insured's premises, or is it at least likely to do so for purposes of the property protection and preservation coverage that we talked about earlier? And secondly, if the virus has in fact spread to a covered premises, does the presence of the virus constitute, quote, direct physical loss or damage, quote, within the meaning of a property insurance policy? So to secure coverage, the insured generally has the burden of proving that the answer to both questions is yes. Unsurprisingly, and for obvious reasons, insurers have taken the position that the presence of the coronavirus neither causes nor constitutes direct physical loss or damage. However, how courts will decide this issue is entirely unclear at this point, as there are no directly on-point precedents. In other words, there are no cases specifically addressing whether the presence of a pathogen or a virus causes physical loss or damage for purposes of property insurance. There are cases out there involving other types of invisible substances or microorganisms, but the holdings in those cases are inconsistent and do not provide clear guidance. Indeed, as you can see on the slide, some courts have reached opposite conclusions with respect to the same substance, specifically asbestos. The holdings in these other cases, which are factually analogous and therefore helpful, show us two things, that the issue often hinges on two questions. First is whether the insured's premises have been rendered uninhabitable or unusable, and second, whether the loss-causing substance or organism could be easily remediated or cleaned. But how these particular questions should apply in the context of a virus is unclear. Fortunately, we should get some clarity soon. Over 10 lawsuits already have been filed across the country by businesses seeking coverage for coronavirus-related business interruption losses, and more are being filed every day. There has been at least one proposed class action filed in Florida by a group of restaurants against various syndicates of the Lloyd's market. And the courts in these cases almost certainly will be asked to address the direct physical loss or damage requirement early in the proceedings, potentially even at the motion to dismiss stage. As just one example of one of these cases, a well-known shoe-design company called the Mark Fisher Footwear Company just sued its property insurer Hartford a few days ago. Mark Fisher alleges that it already has lost $120 million in revenues as a result of its retail customers canceling or delaying payment on spring product orders, and also that because of those lost revenues, Mark Fisher claims it cannot pay roughly $107 million that it owes to its third-party manufacturers, who undoubtedly are now looking to their own insurance to see whether they have dependent business coverage or supply chain coverage. But as Hartford has stated on its website, coverage for coronavirus-related lawsuits, quote, may be unavailable or limited because viruses generally do not cause physical loss or damage to property as required by the policy, end quote. Whether Hartford is correct on this point remains to be seen. I will note that the Akin team is actively monitoring all these cases around the country, and we will do our best to keep you all apprised of any significant developments or court rulings. As Sean mentioned at the outset, we also are monitoring certain related and highly relevant legislative initiatives, which Aaron will be discussing a little later. Another critical coverage requirement centers on where the physical loss or damage takes place, where the coronavirus actually is present or is infecting people. It's not enough for an insured to say, hey, the world's in crisis, people are getting sick everywhere, we need to shut down, therefore I'm losing money and need insurance. Rather, the insured must be able to show that the coronavirus in fact was present at one of three specific locations. First would be the insured's own premises or storefront or office, and that would be for purposes of the standard business interruption coverage that we looked at the outset of this presentation. Second option would be the premises of a customer, a supplier, or utility for purposes of the dependent business, off-premises service provider, and supply chain coverages that we've been looked at. Thirdly would be a premises within a certain number of miles of one of the numbers 1 or 2, and that would be for purposes of the civil authority coverage. Now, this proximity requirement could be really important with respect to the civil authority coverage. And the policies we have reviewed over the last few weeks, the coverage typically only applies if the property damage giving rise to the civil order has occurred within a proximity of 1 to 5 miles of either the insured's premises or a dependent business premises. This may be a non-issue for businesses in dense metropolitan areas or cities that have experienced significant outbreaks. If I'm located in Manhattan, I probably can show that someone or something has been infected or contaminated by the coronavirus within 5 miles, probably within 1 mile. But this could be a significant coverage hurdle or issue for businesses in suburbs, smaller towns, and rural areas, and also for businesses in bigger cities like Los Angeles and San Antonio that are spread out. Dennis, the ball is back to you.
Thanks, Clayton. The next key coverage issue that I'm going to address is the period of restoration or the period of liability. Once coverage is triggered, most business interruption insurance policies restrict coverage to a specific period of time. Sometimes the policies refer to the period as a period of restoration or a period of liability. Now, the definition of period of restoration or period of liability can vary significantly from policy to policy with dramatic consequences. This is a typical example with respect to a period of liability. In this example, the period of liability runs from the period of time from physical loss or damage and ends with all due diligence and dispatch. The loss or physical damage could be repaired or replaced to the same or equivalent physical operating conditions that existed prior to the loss or damage. Unfortunately, this type of definition could prove difficult for insureds to overcome with respect to the COVID-19 crisis. The current guidelines from various medical organizations suggest the virus can survive on various substances from a few hours to several days, depending on the surface, and further that contaminated surfaces can be disinfected with a number of chemicals. Given the potentially short-lived nature of the virus on surfaces, this particular type of definition for period of liability can be highly problematic for insureds and may curtail the availability of coverage, even if it can be established that the virus does in fact cause physical damage or loss. Here's another example that uses a little bit broader language. In this particular example, the coverage provides that the period of restoration will continue until operations are restored with reasonable speed to the level which would generate the business income amount that would have existed if no direct physical loss or damage occurred. Under this particular type of language, an insured has a much better argument for an extended period of coverage. Another coverage issue to be aware of are deductibles and sublimits. Even if there is coverage, an insured cannot assume that the full policy limits will be available. Often, a deductible or retention amount must be satisfied. Deductibles can take the form of a qualifying period of time or a specific dollar amount. Recently, we've seen a lot of policies that have deductibles in the range of 24 hours to 48 hours for many different types of business interruption coverage extensions. In addition, many coverages are capped to a specific period of time or a sublimit dollar amount. In our experience, based on the policies that we've reviewed over the last several months, civil authority coverage is often capped at 30 or 60 days. And for certain kind of very specific coverages, such as communicable disease coverage, we see very modest sublimits. At $500,000 is a typical sublimit, meaning that even if the insured is able to establish coverage under a particular extension, that will be the most that the insurance company will pay for that particular coverage. Another key coverage issue are exclusions. One type of exclusions that will likely be litigated in this context are contamination and pollution exclusions. Now, many policies contain these types of exclusions, and the ultimate applicabilities of these exclusions will likely depend on the specific policy language. Now, typically, we see these types of provisions in most commercial general liability policies and other types of property policies. A typical provision for pollutants is defined as pollutants means any solid, liquid, gaseous, or thermal irritant or contaminant, including various different types of specific examples. And ordinarily, insurance with respect to this type of provision generally does not apply to bodily injuries caused by pollutants that have been dispersed or released from a location owned by an insured. Now, the typical kind of generic pollution exclusion should ordinarily not apply to bar coverage for pandemic losses for at least three reasons. First, exclusions under most state laws are typically narrowly construed. Second, ambiguities are ordinarily construed against the insurer. And three, many states have incorporated or developed or applied some version of the reasonable expectation doctrine, which may be invoked to basically either establish or extend coverage where there are certain ambiguities in the insurance contract. Now, there are also some specific exclusions for viruses. Since the early 2000s, after the SARS outbreak, many insurers started including specific virus or bacteria exclusions. Towards the bottom of the slide is a sample exclusion from a New York policy. And if you look at Section B, it says, "We will not pay for loss or damage caused by or resulting from any virus that induces or is capable of inducing physical distress, illness, or disease." Now, where the policy specifically mentions viruses, like the clause in the last slide, there's likely going to be no coverage. Having said that, the applicability and enforceability of these specific exclusions are being litigated in a number of cases ongoing, and both insureds and insurers can expect more concrete guidance from the courts shortly on this issue. With that, I'll turn it back over to Clayton.
Thanks, Dennis. The last exclusion we want to highlight today is not as common as the others, but it could be really important in coronavirus cases, and that would be the acts or decisions exclusion. We provided a sample from a foreign policy here on the screen, and it provides simply that this insurance does not apply to loss or damage caused by or resulting from acts or decisions, including the failure to act or decide of any person, group, organization, or governmental body. Now, under its plain terms, this exclusion may preclude coverage for losses resulting from an insured's decision to cease operations, whether that decision is made voluntarily or pursuant to governmental order, unless there's a carve-out or exception elsewhere in the policy. The final coverage issue we want to highlight today is the prompt notice requirement that appears in virtually every insurance policy. You can see a sample on the screen, and simply put, it provides these provisions require that an insurer generally must give its insurer notice of any loss, quote, as soon as possible, end quote. Many courts have interpreted this requirement as a condition preceding to coverage, but failing to satisfy it could give an insurer a strong defense to coverage, perhaps even without any showing of prejudice in some jurisdictions. Of course, at the same time, insurers generally are obligated to promptly acknowledge and respond to any notice of loss and to provide a coverage determination as soon as reasonably possible. So both carriers and policyholders need to move promptly. With that, I'll turn it back over to Dennis, and then we'll let Aaron drive us home.
Thank you, Clayton. So in light of these various coverages and key coverage issues, we've created a going forward checklist. First, insureds should consider giving prompt notice of any losses or potential losses, and insurers should aim to respond to any such notices as soon as reasonably possible. Second, we would encourage both insureds and insurers to monitor conditions of suppliers, customers, and dependent businesses, because as was noted in the presentation, their particular conditions could potentially trigger coverage. Third, we would encourage everyone to monitor the various ongoing litigations regarding the direct physical loss or damage requirement, as well as for rulings on various other coverages, such as the restoration period or specific virus exclusions. Lastly, we would also suggest that everyone monitor relevant legislative developments, of which there are many, and which we are now going to turn our discussion to. With that, I'll turn it over to Aaron and Sean.
Thanks, Dennis. As Dennis mentioned, a lot of states have been getting involved in an attempt to provide accommodations to insureds and to address some of the coverage exclusions that Dennis and Clayton discussed with regard to COVID-19. These policies have come largely in two forms. They have come in the form of Department of Insurance guidance or in proposed legislation. With regard to the Department of Insurance guidance, this has largely been limited to simply warning insureds that COVID-19 related expenses may not be covered under their business interruption insurance policies for the reasons that we've already discussed. However, there's at least one notable exception to this, and that was earlier this week, the California Insurance Commissioner issued a notice that required insurers to fully and fairly investigate all business interruption claims from COVID-19. The notice reminds insurers to comply with their contractual, statutory, regulatory, and other legal obligations as it applies to all California insurance claims. The notice also implements certain deadlines. It states that insurers must acknowledge a claim from an insured within 15 days of receiving that claim, and then they must accept or deny the claim within 40 days of receiving the proof of claim from the insured. The notice also provides policyholders with instructions, requires insurers to provide policyholders with instructions, forms, and provide other reasonable assistance in filing claims. As an additional aside, State Department of Insurance have also issued a wide range of other guidance that is generally favorable to policyholders on many matters that are important and relevant to policyholders. Some of this guidance includes guidance on premium holidays, rebates, and prohibition on cancellations. It also includes guidance on deadlines and other technical claims requirements. And we at Akin Gump held a webinar on this topic last week and have been tracking that guidance as well. So if you'd like to listen in on that webinar, we have a link to the recording and as well as the slides that are available when we pass around these slides at the end of the presentation. So the second way that states have been attempting to address some of the coverage exclusions that Dennis and Clayton discussed is through proposed legislation. At least 7 states at this point have introduced bills that would retroactively expand business interruption insurance coverage to losses caused due to COVID-19. Ohio, New Jersey, New York, and Pennsylvania have all implemented very similar or proposed very similar pieces of legislation. This legislation would extend business interruption coverage to losses from COVID-19 that occurred during the state of emergency declared by the respective state government. For these 4 states, the law would only apply to policies covering businesses with fewer than 100 full-time employees, and only to those businesses that had a policy in effect prior to the law's effective date. These laws also allow insurers to apply for reimbursement from the state's insurance commissioner or superintendent for any claims filed under the expansion under these laws. Massachusetts and South Carolina have also proposed similar legislation. However, their bills are a little bit more expansive in that they would apply to businesses with 150 or fewer full-time employees. And finally, Louisiana has taken a little bit different approach. Louisiana has 2 bills that have been proposed, one in the House and one in the Senate. The Senate bill applies to every policy in effect as of March 11th and does not appear to limit the coverage under this law to businesses of a certain size. The law also does not provide for reimbursement, but there is a separate piece of legislation that would establish a business compensation fund, which would be available to any entity providing commercial insurance in the state. Participation in the business compensation fund would be available to any commercial insurer who contributes the greater of either $50 million or 8% of the aggregate policy limits of all policies in effect as of March 11th. Insureds meeting the criteria in the legislation could apply directly to the fund for satisfaction of a claim. The House bill that has been proposed in Louisiana is similar to the Senate bill, except that it does provide a limit on the application of the legislation to businesses with 100 or fewer full-time employees, but it still does not provide directly in that piece of legislation for reimbursement. Several of the bills, such as the Ohio and New Jersey bills, would implicitly override many of the common terms in business interruption coverage that we've discussed today. However, the Massachusetts and South Carolina measures are interesting because they explicitly state that insurers cannot deny business interruption claims on the grounds that COVID-19 is a virus, even if the relevant insurance policy excludes losses resulting from viruses, or, for example, on the grounds that there's no physical damage to the property of the insured or to any other relevant property. Now, there has been a lot of lobbying already on both sides of these proposed legislations. On the one hand, insureds have been pushing for more of this type of legislation around the country. Recently, several major restaurant groups have teamed up to lobby for legislation expanding business interruption coverage for COVID-19. This group calls themselves the Business Interruption Group, or BIG, and is spearheaded by notable chef Thomas Keller of the French Laundry, as well as Wolfgang Puck. Thomas Keller has been particularly active in this realm, and his restaurant group was one of the first to file a lawsuit against their insurer relating to insurance coverage. On the other side of this issue, a number of industry groups are also raising their concerns regarding the costs and other implications of this retroactive legislation with their state lawmakers. In New Jersey, for example, lawmakers are already reworking their bill after receiving significant pushback from insurers. And as we are getting ready to discuss, should these bills actually become law, they are likely to face stiff constitutional challenges. So as we highlighted, the proposed state legislation that would expand business interruption insurance coverage for COVID-19 retroactively is likely going to be met with litigation and constitutional challenges should these bills actually be enacted. The first major issue that these laws would likely face is with the Contracts Clause of the Constitution. Now, courts who analyze these laws under the Contracts Clause would use a three-part analysis that would ask whether the legislation substantially impairs existing contractual relationships, whether there's a significant and legitimate public purpose for the legislation, and whether the legislation is reasonable in light of that public purpose. Notably, retroactive legislation of this nature that changes the terms of insurance coverage has been upheld in many instances where the legislation was a response in an attempt to address a major emergency. For example, similar retroactive legislation has been upheld to insurance contracts following states of emergency related to hurricanes. For example, in a Louisiana Supreme Court case in 2006 called State v. All Property and Casualty Insurance Carriers. In that case, which was a case following legislation that came up as a result of Hurricane Katrina and Hurricane Rita, this legislation extended the period for insurers to file claims against their insurers, and the court analyzing this law under the Contracts Clause upheld the legislation. Outside of the context of national emergencies, courts have been more hesitant to uphold retroactive legislation. For example, in Wisconsin in 2010, a law was proposed that would extend the statute of limitations for certain workers' compensation claims. The court in that case analyzed the law and found that it imposed an unexpected liability on insurers that altered their contractual rights and was not justified by a significant public purpose, so that the law violated the Contracts Clause. However, this is not always true, and in certain situations, courts have been willing to uphold retroactive legislation even outside the context of a major emergency. One example was a piece of legislation, it was a local ordinance actually from Chicago that affected certain landlord-tenant relationships and imposed a $10 cap on late payment fees from renters. And the court in that case upheld the legislation despite the fact that it would have cost the plaintiffs in that legislation up to $4 million. Now, the second potential avenue for challenging these laws is on due process grounds as a potential regulatory taking. In General Motors Corporation versus Romaine, the U.S. Supreme Court noted potential problems with retroactive legislation, stating that retroactive legislation presents problems of unfairness that are more serious than those posed by prospective legislation because they can deprive citizens of legitimate expectations and upset settled transactions. For this reason, the retroactive aspects of economic legislation, as well as the prospective aspects, must meet the test of due process, a legitimate legislative purpose furthered by rational means. A recent decision from a bankruptcy court in New York actually foreshadows some of the issues that could be presented and related to the COVID-19 legislation as it applies to the due process clause. In that case, which was the Pier 1 bankruptcy, the debtor actually filed a request for relief from certain bankruptcy court orders and upcoming payments on the grounds that the shelter-in-place orders had constituted a regulatory taking of Pier 1's property. The court ended up granting that relief. It did not engage in any analysis in granting that relief, so we don't know for sure whether the relief was granted on the due process grounds, but the decision indicates a willingness of courts to consider due process arguments in the context of COVID-19 legislation. And though not strictly analogous, because that case was dealing with shelter-in-place orders as opposed to business interruption legislation, it does show that courts may be willing to apply the takings clause to state actions aimed at addressing COVID-19. But none of this legislation has as of yet been enacted, and so no lawsuits have actually been filed. But should this legislation be enacted, there will certainly be many challenges in both state and federal courts that could prevent these laws from really taking hold. And finally, like we have been tracking the cases that have been, the litigation involved with with certain insurance policies, we have also been tracking the guidance from state departments of insurance, as well as the legislation that has been proposed in many states. And that information is all available on the Akin Gump COVID-19 Resource Center and in the link that is in this slide, which will be distributed after the presentation. And with that, I will pass it off to Sean for some final words.
Thanks, Erin. Just a couple of housekeeping things. Again, if you want CLE credit, that form will accompany the slides and the presentation today, and you need the code AG0417. And if we'll now open it for further questions, please remember you can use the moderator chat button on the right-hand column to ask the question, and I'll take it from there, and we'll do our level best to address your questions. I will note that we have a very broad, quite large group today, and so if you have specific questions that address a specific situation, we're happy to talk with you about that in a different fashion. I will also note on the current events side, well, I guess not so much on the current events side right now. First of all, there is, given the temporal and geographic scope of the pandemic risks associated, for which, in many instances, no underwriting took place and no premiums were collected, I think there will be a healthy fight about whether or not some of this situation is even remotely similar to other situations where the courts have been willing to at least consider retroactive application, making modification to insurance policies. And lastly, I'll note that while there's also a few federal developments, I'm sure you've all seen the comments about business interruption insurance from the president. Also, there have been a number of federal legislative topics at least being discussed. There are, I think, two unformed and two not really within the scope of what we can cover in the time permitted today. But I will say that, as probably many of you know, the Akin Public Policy Group here is without parallel, and they are, trust me, keeping very careful track of what is going on at the federal government level, in particular with discussions about things like small business loans and how insurance might get featured in that, and whether a PREA, which is a TRIA-like backstop, might be something that's being talked about. But that's probably a discussion for another conference and another day. But we are definitely right on top of that. So that concludes our presentation. We'll now deal with your questions through the moderator chat. Thank you for attending and for your attention.
Hi, this is Dennis Wincheffel, and with me as well as Clayton, and we're going to answer some of the questions that we've received through the chat. First question that we received is business interruption coverage part of a larger property insurance policy, standalone, or part of another type of policy? Yes. So business interruption coverage can be part of a larger property insurance policy. It can also be included in other types of insurance policies, including general liability policies. In addition, business interruption coverage can also be purchased as a standalone product. The next question we received is, what is the definition of location, business premises for communicable diseases? What if folks are positive for COVID-19 in your building, but not in your direct space? That's a great question, and the answer to that question will really depend on the specific language in your policy to see how that policy defines location, business premises for communicable diseases. If the definition is broadly worded and includes areas outside your direct space, then there may indeed be potential coverage. However, if the term is narrowly defined, then there may not be potential coverage. The next question we have is, when policy says physical loss or damage, can you recover if damage not caused by physical damage? Do you read into the language the word physical before the word damage, or is damage read by itself so that is not connected to physical? Clayton, do you want to handle that question?
Sure. It's an interesting question. I've never seen that litigated, at least in the context of an insurance policy. I suppose a policyholder certainly could make the argument, or if nothing else, use that to suggest or argue that the language is ambiguous and therefore should be construed in the policyholder's favor. Of course, it begs the question, what does damage, if it's not physical, what would it be then? But, I'm not sure how that would play out. Again, not something we've seen, but interesting question, and it's something at least I'm curious about now, and we'll do some searches on later today, probably.
Thanks, Clayton. The next question is, how can we receive a copy of these slides? We will check with our business folks and mail out a copy of those slides to all those who want a copy of that. The next question is, we saw that U.S. pollution asbestos claims potentially allows for recovery. Do you anticipate the same for COVID losses? Clayton, you want to answer that question?
Yeah, I'm not familiar with the term bending. I suspect or assume it refers to courts sort of liberally applying policy terms, perhaps more so than usual in an effort to find coverage. Certainly could see that happening again in this scenario. Obviously would depend on the particular judge. But again, going back to Aaron's discussion, I really think it's going to be more of an issue of legislative action. Most of these policy provisions that we've discussed today are more on the unambiguous side, I would argue. So, I think there's less wiggle room for judges and probably more work here to be done for legislators, to the extent, anyone's going to, try to create coverage here.
Okay. And Aaron, there was a couple questions on legislation. Do you want to answer those questions?
Yes, I'm happy to. I think one of the questions we got was, how will the legislation apply to businesses that have fewer than the capped number of employees but have a parent company with more employees? And I think that it's likely that those questions will turn on the terms of the insurance policy themselves. For example, the Massachusetts law states that the Act shall apply to policies issued to insureds with 150 or fewer full-time equivalent employees. And so I think that those questions will likely turn on the definition of insureds contained in the individual policies themselves. But of course, some of this might depend on what happens to the legislation prior to it actually being enacted.
All right, thanks, Aaron. This is Clayton again. Let's see. We have a question. Do you feel that if clients receive PPA money funds, that this will preclude the insurance carrier showing there was a loss and the coverage would not apply? Very good question. I don't think that the receipt of such funds would preclude coverage. I certainly can see that it might give the carrier an offset argument. In other words, whatever amount the carrier otherwise would pay would be reduced. But ultimately, we would have to look at the individual specific policy in play to for a definitive conclusion on that. Is AG already assisting clients with BI issues associated with CV-19? Absolutely. I've been working with numerous clients on both policyholders and carriers working through BI issues over the last couple of months. Let's see, does rental loss to a commercial landlord because tenants are not paying their rent fall within the realm of business interruption insurance? Again, I think we would need to see the specific policy in play to come to a final conclusion, but yeah, I think that would qualify. If that's your normal source of income, it should, and it should qualify. It should be covered, provided, of course, you can satisfy the coverage requirements and prerequisites we've discussed today, primarily including the physical loss or damage requirement. Where can I find information on the most commonly adopted coverage extensions by geographical location? Is there such a resource? I'm not sure if any others on the team are aware of a resource. I am not, but I suspect this is something your broker would be able to help you with pretty quickly, pretty easily. So I would suggest reaching out to your insurance broker. Another question, what are the standards for establishing ambiguities in the language of policies? Is there an accepted test? Is it up to the judge's discretion? So, yeah, there are basic rules for determining or interpreting or construing policy language. Generally the same rules that apply to any other contracts. In other words, courts, judges, their job is to apply the plain language using the ordinary meaning of words as they are used on the policy, in the policy. Courts cannot create ambiguities where none exist. They will generally not look at extrinsic evidence to create or find an ambiguity. So only if reading the language and reading the plain applying the words plain meaning, if it doesn't make sense, that's when there's an ambiguity. I guess the ultimate test is whether policy language is susceptible to two or more reasonable interpretations. Are businesses able to make a claim that if their insurance company had a specific carve-out for epidemics in some policies, but none for theirs? So if there is no carve-out in their policy, their omission was deliberate and they should be covered. Good question. That would depend entirely on what was represented to the insured by the insurer. If the insured was promised coverage or an epidemic carve-out or some other specific provision and it did not appear, you might have a claim or cause of action. However, most states are pretty strict in terms of the legal requirements for reviewing your policies. Insureds are held to have, in a lot of states, such as Texas, are assumed to have read and understood the terms of their policies. So, I think that would be difficult to establish with respect to a carrier. You might have more luck with respect to a broker if your broker told you you were going to get some coverage and then they didn't go out and get it for you. Again, another situation where it really depends on the specific facts. We are seeing insured denials that other reasons for coverage denials cite the loss market exclusion. Could you speak to the loss of market exclusion and its application to COVID-19? So I guess that, and Dennis or Aaron, Sean, correct me if I'm wrong, I guess this is going to exclusions that say, we're not going to cover you for general declines in market share or general declines in economic activity generally. I think, I'm not sure how that would play out here. What is the point of business income insurance, business interruption insurance, if you're not going to get covered for lost income, even if that reflects some sort of diminishing market or lost market share? However, at the same time, to get business income coverage, you're going to have to be able to show that you would have actually earned those revenues, but for the property damage. So, you know, if you're a movie theater, you know, you'd have to show that your theaters, you would have been selling out movies regardless. That might be hard to do. So I'm not sure how that would play out here. How is business income typically defined in the policy? Is it more revenue or profit concept? Dennis, do you have any thoughts on that one?
Absolutely. Yeah, it all depends on the specifics of the policy. A lot of policies actually have alternative measures, profits, revenue, and so forth. And some policies actually allow the insurer to select kind of which calculation they would like. And in some sense, it may make more sense to, you know, submit a claim based on profit or revenue or what have you. But a lot of policies do have several options as far as, you know, potential loss, and you know, it really makes sense to explore each of those and determine, at least from the insurer's perspective, what makes sense as far as submitting a claim for.
Great, thanks, Dennis. And by the way, as I'm sure you can all imagine, we are, like I'm sure many of you are, working from home, working remotely. So please bear with us as we're trying to work our way through all your questions. Okay, we have a question. What is the definition of location business premises for communicable diseases? What if folks are positive for COVID-19 in your building but not in your direct space? Great question. I think the first question there is, you know, how is the insured property or insured location defined in the policy? Is it just the street address? Is it the street address plus your suite number? If it is, you know, carrier probably would have a decent argument that that's the only space this policy applies to, and therefore we only respond to property damage occurring within those four walls. At the same time, you know, I think the insured probably has a decent argument or could create an argument that, you know, it's our reasonable expectation that, you know, I would be covered not just for damage in my suite, but if there's a fire 2 floors above me and it's causing me problems, that I should be covered as well. Again, you know, you got to look at the terms of your policy and how the insured property is typically defined. Is there any general advice you have for policyholders that have received an adverse coverage determination letter from an insurer? You know, it's hard to give general advice on that kind of an issue. I mean, the first thing is you've submitted a claim, you've preserved your rights with you know, on that point. I guess it would depend on the grounds for the denial. Strictly based, for instance, on, you know, the physical property or physical damage loss issue, it probably might make sense to sit back and see how some of these lawsuits on that issue come out. But eventually, you're probably going to, you know, need to consult a lawyer on that one. If a policy contains a broad virus exclusion, would you advise the policyholder to pursue a claim under the policy to preserve its ability to benefit if any legislation is passed that would require the insurer to cover losses, notwithstanding the exclusion? That's a great question. You know, I'm not sure if that is necessarily required. In fact, the legislation, I would imagine, would address policyholders who may not have actually submitted express claims. However, generally, would be our advice that if you have suffered a loss, you have any reason to submit a claim or think you might need to in the future, to go ahead and do so. There's really no downside. And the potential consequences of not giving notice be severe. How would you expect the employee limits in the proposed state legislation to apply to an entity with an employee count below the relevant limit that is controlled by a parent company that, on a consolidated basis, has more employees than the relevant limit? That's a fantastic question. I really do not have any insight. Aaron might. I suspect it would depend on the terms of the legislation itself. Aaron, is that something you've looked into?
Yeah, and I think that's what we covered just a few minutes ago. I think for most of the legislation, it's going to turn on the definition of the insured in the policy, because the acts tend to define it as insureds with 150 or fewer or 100 or fewer employees. So I think, again, a lot of that's going to come down to the terms of the individual policy and, of course, how the legislation ends up looking if and when it's ultimately passed.
Great, thanks. Another question that relates to something I was just talking about in terms of giving notice. Question is, will filing a claim jeopardize an insured's policy with cancellation or a negative report to credit rating agencies that would harm their credit score? Thinking circumstances involving owners of privately held companies or individual partners in partnerships or LLCs. Another great question. I do not think an insurance company is allowed to cancel a policy based on a specific loss. So it should not normally, and this is a matter of state law, carriers can only cancel a policy for non-payment of premiums. It's generally the rule. I guess in theory it might create issues at the renewal stage, but this isn't like an insured facing exposure because it has put out a bad product or service or has been committing wrongful acts. This is something everyone is dealing with and is out of people's control. So, I do think premiums might go up just because this is going to hit the insurance industry and that's going to affect everyone. But I don't think reporting a particular loss or potential loss necessarily going to mean you're going to be singled out and that you're going to have to pay higher premiums specifically because of that. As far as your credit rating, I'm not sure I have any knowledge or input on that, but I really cannot imagine that, reporting a loss due to coronavirus would have any impact on your credit score. I think that may have covered them all. Unless Dennis or Aaron, do you see any that I've missed?
Yes, I think we got one more question that just came in. The question says, has there ever been a case of state legislation that has been found constitutional where contract language was retroactively written to expand coverage of losses as opposed to merely extend periods of eligibility? The answer to that is yes. The Chicago case that we mentioned in the presentation actually changed the terms of the landlord's agreements with their tenants and limited the amount of late fees. So it's not necessarily an insurance piece in that one, but it did change substantially the contractual terms of the agreement between landlords and tenants, and the court found that the legislation could ultimately cost the plaintiffs in that case as much as $4 million, and the court did uphold that legislation in that instance. So the answer is yes, it could apply to terms beyond just extending periods, statutory periods, or periods prescribed under the terms of the insurance policy.
Hey, Clayton, this is Sean. Sorry to interrupt you, Aaron. There is one thing on the last question about cancellation or adverse reporting. A number of the Department of Insurance guidances, and this is going to vary by state, so at least one I can think of off the top of my head, and I think there are probably others, sort of prohibit a negative report based on a pandemic type claim. So if you're concerned about that, reach out to us separately and we can tell you what, or look at our tracker and we can tell you what the guidance is there. Sorry to interrupt you, Aaron.
Great, Sean. Thank you for adding that. I think there is one more that we may have missed. In the case of communicable disease, business interruption coverage, how would this policy be considered if the business is declared as critical infrastructure that the management team assumes it should close for safety of employees? Anyone on the team can stop me if this has already been asked and answered. That is a great question. Ultimately, it's going to come down to the terms of your policy. You know, management is in a tough position right now because you have to balance the interests of everyone involved. You know, sending people home exposes you to claims by your shareholders, keeping them at work exposes you to liability to your employees. Very difficult position. But with respect to insurance specifically, it's going to depend on your language of your policy. I'd say most policies that we've seen really do limit this type of coverage to closures ordered by a government. But as Dennis pointed out, some policies and some of these policies we've seen with specific communicable disease endorsements are a little broader and apply or allow coverage where it's the insured that makes the decision. Alrighty, I think that does it.
Okay, so again, thank you all for attending and thank you panelists for your presentation. Please feel free, as obviously we will try to keep you all abreast through the Akin resources of developments that we talked about. But you should also feel free to reach out to any of us to discuss questions as they emerge. We'll be more than glad to assist. Thank you for your time and attention, and hope all of you are well and safe. And with that, we'll end our presentation.